So the Biden administration just told the Supreme Court that they should be allowed to participate in the New York State Rifle and Pistol Association v. Bruen oral arguments. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to finally uphold our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, the Biden administration, through the Solicitor General, is requesting that they be allowed to participate in the New York State Rifle and Pistol Association v. Bruen oral arguments. So if you're not familiar with what this case is, this is a case coming out of the state of New York and is a challenge to the state of New York's concealed carry permit scheme. Here, this case has made its way up to the Supreme Court. The Supreme Court will be having oral arguments on November 3rd. And now the Biden administration is asking that they be allowed to participate in those oral arguments. The New York State Rifle and Pistol Association case is a challenge to the state of New York's concealed carry permit requirements. The state requires a person to provide proper cause to be issued a permit to carry a firearm concealed. Proper cause exists in the state of New York if the applicant for the permit has an actual and articulable rather than a merely speculative need for self-defense. The state does not consider self-defense to be a proper cause, and therefore on that justification alone, people have their permits denied. So on self-defense alone, you cannot be granted a concealed carry permit. Often you are required to show something much more than just self-defense. Proper cause can also exist if the applicant intends to use the handgun for target practice and hunting. However, that licensing officer and agency can restrict that license to that justification. So they can restrict it to just being used for hunting and also for target shooting, which is actually what happened with the plaintiffs here. They applied for a license. They got it on the basis of hunting and target shooting. They wanted to have it to be able to carry in public at large for self-defense, but they were denied based on that justification. Now, the question presented for the Supreme Court in this major Second Amendment case is whether the state of New York's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. So the whole question is whether the state of New York violated the Second Amendment when they denied people's permits when those people only put forward self-defense as the justification for why they should be allowed to carry a concealed handgun. So this is a big case, and it's one of the first Second Amendment cases that the Supreme Court has taken up in a long time. Well, now you have the U.S. Solicitor General, essentially the Biden administration, asking the Supreme Court to let them tag in and join in on the oral arguments. And they did this through filing a motion to the Supreme Court to participate in the oral argument. So here is that motion that they submitted to the court. And it reads, pursuant to Rule 28 of the Rules of this Court, the Acting Solicitor General, on behalf of the United States, respectively moves that the United States be granted leave to participate in the oral arguments in this case, that the time for oral arguments be enlarged to 65 minutes, and that the time be allotted as follows: 30 minutes for petitioners, 20 minutes for respondents, and 15 minutes for the United States. It goes on to state that respondents consent to this motion. Petitioners opposed any motion that would not allocate the argument time equally between lawyers advancing petitioner's position and those advocating respondent's position. This case presents the question whether the New York's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. The United States has filed a brief as amicus curiae supporting respondents arguing that the denial of the applications is consistent with the Second Amendment. The United States has a substantial interest in this case. Congress has enacted numerous laws regulating firearms, and the United States has a substantial interest in defending the constitutionality of those laws. The United States has previously presented oral arguments as an amicus curiae in two other cases involving the Second Amendment: New York State Rifle and Pistol Association v. the City of New York and the District of Columbia v. Heller. The United States' participation at oral arguments could therefore materially assist the court in its consideration of this case. So that is the motion that the U.S. Solicitor General has presented to the Supreme Court. And to sum up that motion, the U.S. federal government is asking to have a representative participate in the oral argument, and at oral arguments, that U.S. representative will argue against your right to carry firearms in public for self-defense. And there is no surprise that the respondent, i.e. the state of New York, supports the U.S. Solicitor General being able to participate in the oral arguments. However, petitioners, the New York State Rifle and Pistol Association, do oppose the U.S. Solicitor General participating in those oral arguments, primarily because what is going to happen then, if the U.S. is allowed to participate in those oral arguments, is that more time will be allocated in the anti-2A side. So essentially, they will get more time to argue against your Second Amendment rights, and the representatives arguing in favor of your Second Amendment rights will be at a time disadvantage at the very least at those arguments. Now, you may be asking yourself at this point, how in the world is the U.S. federal government through the U.S. Solicitor General getting involved in the oral arguments in this case? Well, the United States Solicitor General represents the federal government of the United States before the Supreme Court. The Solicitor General also determines the legal position of the U.S. when they argue before the Supreme Court. In addition to supervising and conducting cases in which the government is a party, that office and the Solicitor General also file amicus briefs. So if you remember a few videos back, I talked about the Biden administration filing an amicus brief before the Supreme Court in this case. Well, that amicus brief was written by the U.S. Solicitor General. And now they're saying they have a substantial interest in this case, and they should also go beyond just being able to file that amicus brief, but also participate in the oral arguments. And if you wanted to know what they are going to argue before the Supreme Court, just watch that video and they outline exactly what their position is. And their position is that the Second Amendment does not protect your right to carry a firearm concealed out in public for self-defense. So this isn't great news, but I will definitely be keeping my eyes on this and let you guys know what exactly happens. But the likelihood is that the U.S. Supreme Court will let the Biden administration / the U.S. Solicitor General participate in those oral arguments. The Solicitor General has generally been permitted to join oral arguments in Second Amendment cases. For example, reference Heller and the New York State Rifle and Pistol Association v. the City of New York case that they also reference in their letter. If you listen to those oral arguments, the Solicitor General was allowed to argue before the Supreme Court in those cases, and the likelihood is that the same will happen here. What the time allocation will be, we will see, but again, not great news that you have a representative of the U.S. arguing before the Supreme Court that you do not have a right to carry a firearm out in public concealed for your self-defense. So if you guys have any questions, go and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys definitely impacted the last video. You guys added so much fuel to that video and it definitely broke the algorithm. So thank you so much for all the support. And again, if you don't have a comment in mind, just comment down below that you're coming to fuel the algorithm, and I really appreciate that. So as always, thank you all for watching. Don't forget to like and subscribe, and don't forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.